is Protected Thoughts from the Intellectual Property Team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit mcbrayerfirm.com.
Welcome to Protected Thoughts. I am Mary Elise Paul, and I am here with Bruce Paul.
Good evening.
It's been a while. Where have we been all summer?
Well, this summer I was at the Copyright Society, which was held in beautiful Cleveland, Ohio, at the Rock and Roll Hall of Fame, and I joined you at INTA.
Yes, in warm, sunny Atlanta, Georgia. We were there with Katie as well.
And Jack.
Jack was there as well, yes. We also, all of us, were on vacation, and we were sending kids off to college.
Fun times. Very expensive.
And one off to kindergarten.
Even more expensive.
Speaking of, on our way to drop one kid off to college the other day, we realized that we really need a podcast because we really need to talk about how the brand identity of the Tesla has changed. Do you agree, Bruce?
It appears that way. It feels a little different to own a Tesla in 2024 than it did in 2020.
You still love your Tesla just the same. However, let's say the brand identity has changed a bit. The respect of the acceleration of the Tesla is not the same anymore. When you were, I guess you can tell the story.
It accelerates every bit as well. It's a little embarrassing to own one.
And why is that?
Elon doesn't have the same reputation he used to, and has obviously done damage in a lot of people's opinions to his own reputation, the Twitter brand when he purchased it.
Now X.
And he's become very politically involved and has been involved in just a lot of issues that are controversial, to put it mildly. And so, there's just a lot of value fluctuation in whether or not what he has done is what it once was valued at.
I think he's a polarizing figure. And maybe if you have a Tesla, then you love the car. And so you can look past some of that. But you can appreciate the convenience of it, the supercharging, the pressing of the door, and how the button makes the door open, all of the wonderful features. You can look past his reputation and again, some of the polarizing behaviors that have been damaging for the brand.
I mean, Tesla has had its issues. There have been allegations that self-driving mode doesn't work. There's data protection issues. There's no shortage of criticism of the Tesla product, to be sure. But he was seen as ahead of his time. He was doing wonderful things in space. He was doing environmentally friendly things, a lot of people thought, and now the goodwill is all but gone. So the product, in my mind, the Tesla car, is still the same, but it is definitely, the value is way less. And you can look at Tesla stock and see that. But in terms of what we were going to talk about tonight, he owns everything. So we're going to talk a little bit about brand value and language that's in contracts of sponsors and influencers. But when you're Elon Musk and you are the brand, you are Twitter, you are X, you are SpaceX, then in some ways it's his money that's becoming devalued. In other ways, it's baked in.
Would you be surprised to know that statistically the brand value has increased steadily over time? So even this year, as of July 2024, the brand value was ranked at $71.9 billion, which was up from $68 billion in 2023. So that's an increase of about 6%. So despite all of what we've just discussed, the brand value is still increasing.
And that's for Tesla?
Mm-hmm.
Yeah, that's surprising to me.
Yeah.
I mean, the other example of that, which is even more polarizing, I suppose, and this is not a political podcast, but it's the Trump brand. Truth Social is a social media platform that was owned or is owned by a stock called Trump Media and Technology Group, DJT on your stock market for those interested in purchasing. And it's complicated because the stock was created for the sole purpose of purchasing that platform, but it has quarter over quarter lost a lot of money, made no money, but it's a stock that people who are Trump supporters are eager to own. And so it again is just a baked in value. The product is a minimally used social media platform, but it's got value. And, in the past year, Donald Trump, for example, was found liable to E. Jean Carroll to the tune of several $1,000,000. The Trump organization has been found liable, I guess, in a corporate lawsuit in New York. And those verdicts did not meaningfully impact the Trump stock. Now, it's taken a hit. Looks like in April, it was at a high of about $67, and right now it's $20. So it's on its way down, but still it's a popular stock and it's losing way more money than that at any other stock. If this were the Bruce Paul stock showing similar revenue earnings, it would be not marketable at all.
Well, what's particularly fascinating about, I guess, the Donald Trump brand value is following the convictions back in what? It was June, I guess. I think arguably his brand...
In fairness, it's not convictions. It's civil, but...
Sure. Wrong term. So his brand value went up. He raised more than $60 million for his campaign right after the verdict. And they actually fueled a surge. The RNC said they raised something like $141 million in May 2024. And typically this doesn't happen when there's any sort of, anything deemed by the general public as immoral or scandalous or any sort of negative publicity. But in this case, what could be, I think, objectively viewed as negative press fueled an increase in fundraising and maybe an increase in his brand value, which is just not what we see.
Yeah. And again, if Donald Trump had an agreement with Adidas or Foot Locker or Vogue or Christian Dior, they would likely drop him for that. But instead, Donald Trump is the brand. He is the owner. And so he sinks or swims with that reputation. And everyone knows that whatever that reputation is, whatever you think of that, it is what it is. It's all baked in.
And again, we're not here to opine on it. This is not a political podcast. We're just here to deliver the IP law and our opinions on that as we see it. And so as, part of our practice, we draft influencer agreements and have experience with endorsement deals and brand deals. And often these deals will contain morality clauses. And when something controversial, inappropriate, or offensive happens, brands will reserve the right to terminate partnerships with the influencers or the celebrities. And, we don't typically see celebrities making more money for a conviction or some sort of offensive behavior. And like you said, Gap, Adidas, we can look back in time for these patterns. Adidas terminated a partnership with Kanye West following his anti-Semitic remarks. So the Yeezy shoe, incredibly popular for a long period of time. And then Kanye West made those remarks and Adidas terminated that relationship. And now they waited for that period of time, but then they've relaunched the Yeezy under their own brand.
Yeah, going back in time, some of the most famous names historically have been dropped by brands. Looking back in 2008, Sharon Stone was dropped by Christian Dior for comments about China. In 2004, Whoopi Goldberg was dropped by Slim Fast because she made sexually explicit puns about President Bush regarding his name while she was supportive of his opponent. And
and if I can just interject there, I think that you can see kind of how times have changed from 2004 to 2024 with, sexual innuendos and the presidency and the candidates. She was dropped as a spokesperson for these sorts of puns. Sorry,
I think that's fair. It's, we're in an era of, times are very different. 2024. If you say or do or write something, chances are it's been recorded. So there's no pretending it doesn't exist. There's no hiding it, burying it, deleting it. And, no matter where you are in the political spectrum, there is an adversity to quote unquote cancel culture. And there is a belief in First Amendment rights. We should be able to say or do whatever we want. And rah, rah, of course, that's great. It's a great part of being American. But if you're making money from a brand, then you don't have that unlimited First Amendment right if you're going to accept that money.
You have to behave in a certain way and behave in a moral way, which, speaking of, Tiger Woods is another good example of this. Back in 2010, he was dropped by a lot of brands, Gillette, Pepsi, Accenture, and AT&T, after the news of his extramarital affairs were made public. Michael Phelps is another good example. There were photos of him that were leaked smoking marijuana, and Kellogg's terminated their endorsement deal with him. That was back in 2009.
So as you're writing these agreements, what language do you write? Does the endorser have any rights in this? Can they negotiate it?
Well, it depends on who you're representing. Typically, we're representing the brand, so you want to be conservative and give the brand the right to terminate an agreement if the endorser or the influencer is behaving in a controversial way. But, the May language leaves some wiggle room for that. If you are the influencer or the endorser, as you said, you probably are opposed to these clauses because what is considered, quote, moral may change over time. And what one person perceives as moral is maybe different than what another person perceives as moral. So, this is often a point of negotiation and pushback. And, we talked about marijuana, for instance. In some states it's legal, in some states it's not. So where do you draw the line on that? These are all things that have to be considered and discussed and negotiated when you are working out the agreement between the brand and the influencer endorser.
Well, and it's unlikely that the provision would bar marijuana. It's probably just a blanket drug agreement. So what is a drug? And
exactly.
In some states it would be an illegal drug, could be marijuana, and others it couldn't. Ayahuasca, any of these things. Painkillers, what if I become addicted to a lawfully prescribed, legally used painkiller? I would be then using it, but that could reflect poorly on the brand, and that's tricky. That's tricky because addiction is a sad thing, and so to get dropped for breaking a influencer agreement over a drug provision when the drug provision kicks in because of an addiction, these are the things that lawyers don't have good, clear answers to.
Right. I think best practice is to be thoughtful when you are drafting these agreements and think about all possibilities and be flexible.
In the last segment, we started about us talking about the Donald Trump situation matter, and, he's constantly in the news. And most recently, you sent me a screenshot of he reposted on the aforementioned Truth Social that something about Taylor Swift. What was that?
Oh, yeah. So Donald Trump posted apparently an AI-generated image of Taylor Swift pointing with the text, "Taylor wants you." Trump commented on the AI-generated image, "I accept." So obviously the implication behind this post is that Taylor Swift has endorsed Trump when she has not. So what's particularly interesting here is that Taylor Swift has been known to not be shy about attempting to enforce her rights, enforcing her rights, filing lawsuits. And to date, and this happened, I think, last week at this point, she hasn't brought suit over this, but, could she? Might she have?
Well, certainly. I mean, most states, well, heck, where does she own homes?
Rhode
California,
Island.
Tennessee. Okay. I don't know about Rhode Island, but certainly Tennessee and California have right of publicity statutes. They also have common law right of publicity provisions. And so I don't think there's any world where he didn't use her likeness to promote him.
Absolutely.
To falsely say, well, she's not denied it, so I suppose jury's out on that. But assuming she did not endorse him, yeah, he used her likeness and created a buzz, and that's actionable under California and Tennessee's right of publicity statute. Well, certainly under common law right of publicity claims in those two states. The statute's a little harder. Knowingly, I think he probably knowingly did it.
Oh, I think so. I mean, you're intimately familiar with these California right of publicity statutes based on your work. Would the fact that the AI, I mean, presumably he reposted an AI generated image that he didn't create. I guess there's commentary about that. He's certainly using her name, image, likeness.
Well, the result is no different. Well, had he had an artist draw that picture of Taylor Swift endorsing Donald Trump, then that would be actionable. The fact that he pulled that image from AI doesn't make it safe or less actionable. I don't think. I can't think of anything.
No, I don't think so either.
I mean, I suppose the statutes as written have not contemplated AI, but the fact of the matter is whoever created that was using her name, image, likeness to falsely endorse him and game, set, match. That's it.
Or, I don't know all the detailed circumstances of it. Did he just share it and say, I accept? Did someone else make it? Is his campaign responsible for it? I don't know all these specific details. I suppose that also plays a role too. The other possible claim is a false endorsement claim under the Lanham Act. So is anyone actually confused? I don't know. I suppose if you polled the general public, people may think that she did this. This is real. I can't speak for that. What are the damages?
Help us out. What is Lanham Act claim, false endorsement? What does that mean? What are you talking about there?
So the Lanham Act is the statute that governs trademark law, federal statute that governs trademark law. And there is Section 1125 governs unfair competition, false endorsement, false affiliation claims. So it is foreseeable, I think, that there could be a false affiliation or false endorsement claim that would be applicable here under that trademark statute.
Does Taylor Swift have to be a registered trademark for that?
No.
Is Taylor Swift's name federally registered?
Oh, I'm sure.
It's just her name.
Well, I'm sure it's registered for use in connection with a broad variety of goods and services. She does sell a fair amount of merch at her concerts. I'm the proud owner of a Taylor Swift concert tee.
What if someone else is named Taylor Swift? Would they also have an actionable claim against Donald Trump?
Oh, now we're really getting off the rails here. It's clear she is in the picture, so it's clear that they're referring to the particular Taylor Swift who is the...
So it can't be, the 15-year-old Taylor Swift in Louisville suing.
I mean, maybe there's some sort of claim, but I think where there's the picture of Taylor Swift, the artist Taylor Swift, it is clear that the post is speaking of the musical artist Taylor Swift that we all know and love.
So do you think she's going to sue?
I don't know. I mean, she's known to send cease and desist letters. She's known to, I can make a really bad pun about her shaking it off here. Or she could just send a cease and desist letter, or she could bring suit. I think if it hasn't happened by now, then probably not. She could make an endorsement of a candidate and put an end to any possible confusion as to who she's endorsing.
Yeah, Google is not telling me if she sent him a cease and desist letter. I think it's stunning that she hasn't. I don't think that most of the general public would believe that the endorsement was real, but it's campaign season right now. It's almost an everyday occurrence that musicians are sending the campaigns cease and desist letters just for playing music. I know the Foo Fighters just told the Trump campaign to stop using the song Hero.
Really?
Yeah. And that's pretty old hat. That happens every campaign season. Usually it involves Bruce Springsteen. But yeah, I'm really surprised she hasn't sent anything. Again, maybe she's okay with it.
I don't know. I guess we'll have to wait and see. Tune in next time to find out.
You're not going with the pun? See if she shakes it off?
I already kind of said it, but stay tuned. Well, thank you for tuning in. Listen next time for the next Protected Thoughts episode. And remember, we're lawyers, but we're not your lawyers. We do love talking about the law, though. We will see you back here next time on Protected Thoughts. Check us out on McBrayerFirm.com. See you later, Bruce.
See y'all.
All content copyright 2024 McBrayer PLLC. All rights reserved.